Welcome, everyone. My name is Talia Gonzalez. I'm the co-chair of the American Bar Association's Committee on Alternative Dispute Resolution and Restorative Justice. And it's my distinct pleasure in hosting now our fourth webinar that's really conceptualizing, helping us understand restorative practices more deeply. I do want to make a notation in a couple ways. One, we are not offering this for continuing legal education credit. So for those of you that are joining us, that be aware. And second, that this is an event that is supported and co-sponsored, not just by the committee, but also by the American Bar Association's Criminal Justice section. And I'm delighted to be joined by two practitioners. If you were joining us and you were thinking about sort of what was the focus of today's conversation, two practitioners that are really going to help us unpack not just the concept of restorative justice, but what it might mean as it exists in practice. And in fact, you know, arguably in two sites that seem both different in location in the country, but also the types of harms and crimes and transgressions within the state that are existing. My colleagues today have asked that if I can just go ahead and put their bios in a shared chat. And so I might just put it in the Q&A or see if I can put it in the chat for everyone to be able to see if it's not restricted. And so sort of not taking time in our conversation for doing that. I will introduce, though, to my right, and I don't know if that's to your right, I am joined by Ames Stetson, who serves as the Inglewood Municipal Court Restorative Justice Program Manager, and I will let Ames be talking more specifically and thinking about that program. And then to my left, Rami El Harib, who is at the Georgia Justice Project and is focusing and working there as the first restorative justice program manager. Again, different parts of our country, very different practices and work they're doing. And so I'm just more and most excitedly ready to turn it over to them, because you should not be hearing from me. You should be hearing from folks who are working in the field. And so with that, I'm actually going to mute and turn my video off and turn it over to our featured panelists. And then if there are any questions, please do put them in the Q&A function, and I will see them. Our panelists will see them, but to the extent that we'll make sure they're answered. I also had the opportunity to check in with both of our panelists, and where there's questions that you might have in the moment, they are both very open also to an interruption relative to raising your hand or sort of putting something in the Q&A and kind of keeping track of it that way if there's a real-time question that should be grappled with as well. And so with that, I turn it over to our panelists, and thank you again for being here. We really appreciate it on behalf of the ABA.
Thank you, Dr. Gonzalez. Thank you, Patrice. Hi, everyone. My name is Ames Stetson. I use pronouns they, them, theirs. So I'm really thrilled to be with you all just to share a little bit more about restorative justice as we've defined it with our Inglewood Municipal Court Restorative Justice Program. So I'm just south of Denver. Hoping, so Rami and I were thinking of each kind of sharing a little bit about what our programs consist of, and then hoping to be in conversation around some of the similarities or some of the things that we've seen work or some challenges as it relates to our programs and implementation, etc. So just to get started, I am going to share my screen with you. It's not a ton of slides, but just to give you a little visual here as far as how our restorative justice program started. So we're also going to be talking about how we define restorative justice. Hoping we can get into some more conversation as well about how restorative justice practices are actually not alternative dispute resolution practices, and kind of pull some threads around that out in our conversation. So let me just share with you my screen here and give you a little bit more background. So our restorative justice program here in Inglewood started actually back in 2021. So Colorado has more than 50 programs, restorative justice programs here in our state. Inglewood is one of the newer programs. We only started here taking cases in 2021. And we started through conversations informally and then formally with a variety of folks from our community. So different community leaders in the city, as well as judicial leaders, police departments, victim services, community members, school district, to say, we want to bring restorative justice practices to the Inglewood community, but how do we do that and what does it look like? And so through about a year of conversation and really looking at what are the models, what are our options, we pitched as an advisory team for the municipal court to be the house of and to house our restorative justice program for the first 3 years of implementation, so that we could really build up systems, processes, data, volunteers, engagement in what we're doing and what we're trying to do. So one of our really champions of our restorative justice program is our judge here in Inglewood, Colorado. He is actually our only municipal court elected judge in the state of Colorado. And so Judge Jefferson has been incredibly supportive of our work and really sees it as part of overall system-wide criminal justice reform. And so I always like to just name of kind of where our program sits within the values of the court and the mission and goals. I guess I want to pause because I'm making an assumption here that many people kind of even know what restorative justice is or some of the history. So just to briefly say, and maybe Rami, we can talk about this more, but to name that restorative justice is actually kind of considered the oldest form of justice there ever has been in humanity. It's really looking at what are the needs that exist and what are the harms that are caused when we harm one another, whether it's to the level of a crime or not. And then in repairing that, how do we respond to the needs? How do we meet the needs based on that harm and what's needed to repair? And so, as practitioners here in our kind of current day restorative justice framework here in the United States of 40 plus years, we're actually utilizing and engaging in practices that have been around for thousands and thousands of years from Indigenous and Aboriginal people from across the world. So just want to name that piece. I apologize for not naming that before. So fast forward many, many years to the Inglewood Restorative Justice Program. This is how we define restorative justice. I'd like to say that if you ask 10 different restorative justice practitioners what the definition is, you're going to get 10 slightly different responses. But here's how we've defined it as we use these processes and tools within our criminal legal system, right? So we say that restorative justice practices are victim-centered, community-based responses to a crime or conflict. I'm going to pause there for a second. So victim-centered in that in order for a case to come through our program, the victim or harmed party has to give consent for the case to go through restorative justice. So they have to be willing to say, yep, this case can go through rather than go through the municipal court. If they don't give consent, then we're not able to take the case. Secondly, we say that it's community-based because we use a model called the community group conferencing model. It's one of the RJ models, if you will, which allows responsible party, harmed party, and community members to be in a facilitated conversation to talk about what happened, who's been harmed, and what needs to be done to repair that harm ultimately. So in that, we're bringing in community members to participate in what are the larger, most larger impacts on community when an assault occurs, when a shoplifting occurs. It's not just the one and done, right? It's that ripple effect of when crime or harm occurs. What is the larger impact? So that's how I want to kind of help frame for y'all the victim-centered community-based piece. And then we engage in an opportunity. So these responses create the opportunities for then accountability. That's something that is required in order for a responsible party or offender, defendant, right, to go through our restorative justice program. And then we emphasize repairing harm and restoring relationships through the program. So just to give you, again, lots of kind of 30,000 foot view, but trying to give as much information that might feel helpful to give you a snapshot here. So the way that our program receives cases is that an Inglewood police officer would recommend a case to come through our program. It's then reviewed and officially referred to the program by our city prosecutor. And then it's signed off by the judge to say, yep, the court case can be put on hold. It's going to go through restorative justice. So for our juvenile cases, it's considered a pre-arraignment process. And for our adult cases, it's a deferred prosecution. Basically, folks have 5-6 months, at least at the beginning, to say, all right, the court case is put on pause, and you're going to have them the opportunity to go through restorative justice if they choose to. It's a voluntary process for everybody involved. Here's a list of common cases that you might see come through our program. Again, we're a municipal court program, so we see lower level cases. We see any cases that would otherwise be filed within a municipal court, so they're all misdemeanors. We don't accept any traffic related offenses, or if someone has a warrant with us, we're not able to take their case as a RJ case. And then we also don't take any domestic violence cases in our program. As you see, we have about 80% youth referrals and 20% adults. So again, to give you a quick snapshot of our data, we don't have a ton because we're still a pretty new program. And so just want to name a few things here. Generally speaking, at least here in the state of Colorado, oftentimes programs that are working with or maybe embedded in the criminal legal system tend to land on 3 points of success, right? These are our measurements for now, for better or for worse. One is satisfaction of participants from their restorative justice conference. So a post-conference questionnaire, how was that? What did you learn? Did you feel like people were held accountable, et cetera, right? And then the percentage of folks that have completed their accountability contracts. How many people go through the process and then actually complete that accountability contract that we create in the process to hold them accountable and to help repair those harms and heal harms. And then thirdly, we look at recidivism rates, reoffense rates, right? So if people complete their accountability contract, what is a year out from when they've completed, are they reoffending? So just to give you a little bit of an idea, we've had 132 cases referred to us since we started taking cases. And then when people go through the process, 97% of those feel like they were satisfied with the outcome. 98% of participants feel like the responsible party was held accountable. And then we're also at a 90% completion rate for responsible parties completing their accountability contracts. I will just name that 132 cases have been referred. That doesn't mean all of those cases have come through restorative justice, because maybe those 2 requirements have not been met of victim consent. And I don't know if I said this before, but responsible party has to be taking some level of accountability. So if those 2 requirements are not met, those cases can't go through our program. And then as of right now, again, caveat that this isn't a ton of people at the moment, but as of right now, we actually have a 0% recidivism rate for responsible parties who completed their accountability contracts in 2021 through 2022. And I also just like to name, because getting communities involved in restorative justice practices is really, really important for building programs, but also sustainability and helping to kind of integrate these deeper practices and changing culture. It's really important to get volunteers involved. So we've got a really robust group of folks here in our community. I'm going to stop for a second because it looks like, there's a question. What about stop arm violation? Stop arm violations. And I apologize, but can you just tell me more? What do you mean by that? If I could get clarity on that question, and then how many cases get denied through the referral process? Yeah, thanks, Amanda, for your question. So I was actually looking at those numbers. We had of the cases referred to us in 2021, 80% of those ended up coming through our program. In 2022, 68% of the referrals ended up coming. And then so far this year, we've had 83% of the referrals come our way. I will say that only a handful of those have been because the prosecution didn't agree that the case should come through restorative justice, but mostly it's that the person was initially referred to our program, but then they chose not to go through the program. Hopefully that answered your question, Amanda. Kathy, someone who drives through an extended bus stop. I apologize. We don't take these cases. So maybe Rami can speak to that, or Talia can speak to this a little bit more. So thank you for that, but I'm going to pause. Okay, great. So the last thing, and actually I'm going to save this slide because I feel like it kind of brings us into recommendations and other resources. But I think for the sake of kind of grounding in context, Rami, I'd love to pass to you so that folks can kind of hear outside of just the muni court system where else we can be using restorative justice practices.
Great, thank you, Ames. And thank you, everyone. Welcome to this panel dialogue webinar. So my name is Rami Al-Gharib. I'm the Restorative Justice Program Manager at the Georgia Justice Project. We have created a restorative justice program called Restorative Justice Georgia. Before I dive into how it works and what are the mechanics and more details, I would like to give my definition of restorative justice. It is very similar to Ames' definition. However, when speaking to folks, I personally like to define it as a facilitated dialogue between the defendant and the victim and their support people, if they would like support people there, to explore what happened, what the impacts of the crime were, and how to make sure it does not happen again. And through that process, they come together and form an agreement based on the needs of the harmed party, the victim, and based on the defendant agreeing to those needs. After that agreement is completed, that is what I would call restorative justice for me, based on my practice in criminal justice. And so also, before diving into how my program works, I would like to start by sharing how I started this program, the journey to get to building a restorative justice program within Atlanta, Georgia. And that was a long journey. So I was originally in Colorado doing this work, and I moved to Atlanta, Georgia at around June 2021. And there were no restorative justice programs that were well established here. And so my journey to build one started there, where I reached out to a restorative justice advocacy group who got me in contact with a district attorney's office. That district attorney is Sherry Boston, the DeKalb County district attorney here in Georgia. Her office was very interested in creating a restorative justice program or referring cases to restorative justice. So that really helped me build this program. And at the same time, there was a nonprofit, the Georgia Justice Project, looking to build a program, but needed a practitioner to start it and to help shape the program. And so it was a great way to connect all three entities, me, GJP, and the DeKalb District Attorney's Office. And from there, we started having conversations of how we would like to build the program, what cases we'd like to take on, who we'd like to train, and just the mechanism of evolving this organization and Restorative Justice Georgia. And I would say it really helped by having a great district attorney like Sherry Boston be so supportive in starting with taking felony cases of crime and wanting to start with that. And also, she had also run another district attorney, Dalia Racine of Douglas County, Georgia, to also partner with us to start this program. So that was really, really helpful in being able to do that. We also spoke to the public defenders to get their buy-in. We trained their offices, and that's how the program came together. And so I'm just going to share my screen to talk about the program now in more depth. So as I mentioned, my program's name is Restorative Justice Georgia. It is a restorative justice program where we take pre-indictment felony cases for adults and youth who are facing, those felony cases, and it works as a diversion program. So if they successfully go through restorative justice, their case is either dismissed or their charges are reduced. And so as this chart shows, someone commits a crime or harm occurs, the person's arrested, the DA gets the case. Before it goes to court and before an indictment happens, it gets sent over to me, where I start working on the case. I start by contacting the victim and the defendant to to speak about their willingness to be able to do this. If they would like to do this, it's voluntary, it's confidential. And so I'm going to just skip ahead. And so when speaking to the defendant, I assess for three things: willingness to take accountability, meaning acknowledging that you caused harm, being able to speak to the harm from the other person's point of view, and taking steps to make amends. The other thing I assess for is a willingness to show remorse. And the third thing I assess for is a willingness to not repeat the behavior. If that is there, or if there is a willingness for all three of those components, then I move forward. In speaking with the victim, I asked, what happened? Acknowledge the harm. What needs do you have? What would you like to achieve from speaking to the person who has harmed you? And how do you know if your needs are met? And what are some of those agreement items that we spoke about before, that accountability agreement? And so after preparing both for several meetings, we come to that facilitated dialogue to explore, as I mentioned, the harms and what needs to happen. And so going back to partnering with the district attorney's office, I have given the example of partnering with the DeKalb County District Attorney's Office. So to start determining the right case, cases must have at least one identifiable victim. Ideal cases of referral include theft, burglaries, robberies, assaults, armed robberies, and arsons. The DeKalb District Attorney's Office has indicated to me that they will not refer at this time homicide, sexual assault, sexual exploitation, domestic violence, or child victim cases. We made sure when discussing a memorandum of understanding and building that this is victim-centered and it's voluntary. And as mentioned before, I evaluate the case before moving forward with the conference. Also, everything legal, as in legal evaluations and the agreement happens before it gets referred to me. So I am not a lawyer, I'm not a judge. I don't want to be responsible for folks to determine folks' sentences and decide based on that. So that all goes through the district attorney's office. We get folks to sign a defendant advisement form, we get victims to sign victim advisement forms, and then it comes to me so that those expectations are already set. Conversations that folks should have with the defendant and victim when going into this process is that it's voluntary. When speaking to the defendant, if you are their defense attorney or public defender, it's important to let them know that accountability is required for this to move forward. This is not mediation where we're coming to a common ground. This is us acknowledging what has happened and finding ways to move forward with it. I have mentioned immigration concern because after speaking to some immigration attorneys, there is a distinction that they made between state prosecutors and ICE prosecutors, and that if someone does admit to harm or takes accountability, that may impact their immigration. But the DA's office lets folks know that there may be immigration repercussions before signing into this, so please make sure you speak to an immigration attorney beforehand. It is confidential. We have signed a confidentiality agreement with the DA's office, meaning if I refer a case back because someone is not taking accountability, if they're not appropriate for the program, they won't ask me about what I spoke to them. They won't have access to my records. There's no access to anything. Even if there is someone within the program who decides to voluntarily share more information with the DA's office, they can't use that against someone. It's everything that happens within the process is confidential. And then, as I mentioned, legal outcomes are determined prior to admission into the program. As I mentioned, confidentiality is important. There are several layers that we agreed to. There's a memorandum of understanding we have with the district attorney's office. There's a consent form agreement that I do have the victim and defendant sign before moving into this process, that this is confidential and you can't subpoena anyone. And you agreeing to be in this process means that whatever we talk about here stays in this space. And then it's also ethically required in restorative justice. I mean, if someone is sharing with me very deep and personal details, for defendants, for example, that helps give context as to why they committed certain crimes, or for victims, usually I'm one of the few people they do share the impacts of a crime, that, you know, how that's affected them. It would just not be very ethical of me to go and start sharing it with folks, or for me to go to court and start sharing that with a judge or with folks in court. And so mechanism, you know, the district attorney sends over a police report and supplementary documents. I assess those documents. As I mentioned, I call the defendant and victim separately. I meet with them in a neutral space. Their support people are invited. And it's very important to also mention trained facilitators are important to do this process. If someone has taken like a 2-day restorative justice crash course, that is not enough. Make sure if you're starting a restorative justice program, or you would like to maybe employ a restorative justice facilitator, that they have received extensive training and coaching and mentorship, and they are trauma informed, because some of these stories are very sensitive and can be very triggering to folks. And there are 3 parts of the restorative justice process. As I mentioned, a pre-conference where I prepare folks, the conference where the meeting takes place, and then I follow up with them afterwards to speak with them about, how was this experience for you? Is there anything you'd wish you'd said? Or is there anything that I can do to have made this experience better for you? Or how are you feeling? And so those are the 3 processes. So I will stop sharing. And just make sure there aren't any questions, but that's a bit about my program. We have received, so we started this program, it took about 1.5 years to build. So we started accepting cases a few months ago. We have 13 cases referred from one county, and then about 10 from a different county that are about to be a part of Restorative Justice Georgia. So for the year of 2023, about 23 cases. There are more district attorneys who are interested in partnering with us. However, we have to scale it the right way. I have to train a lot more volunteers, and also in training volunteers, they have to be really well prepared before they start taking certain cases without me, at least.
Great. Thank you so much for those opening remarks and sort of presenting the frameworks. I know we've had a couple questions in the Q&A that Ames has actively been answering. There's one outstanding, and then I welcome others to put questions in there now, both to both panelists, and be kind of building out the conversation in that way. So Ames, do you mind taking the first one that's still outstanding?
Yeah, absolutely. So what do accountability contracts look like? So for our program, we ask and invite folks to be creating an accountability contract in the conversation as a group. So we're not saying to responsible party, you have to come up with your own contract. We're not saying facilitators, you have to now say, here's what you're assigned to do. We actually ask and invite the harmed party, if they're participating, or a surrogate, to name what is it that they need. And so we look at building an accountability contract, generally 3 to 5 items or tasks that are SMART with 2 S's. So we say specific to the incident, strengths based on the responsible party's strengths and interests as much as possible, measurable, how do we know when it's completed, achievable and realistic, and then timely. We come up with a deadline of when those items are due. And so again, we're always inviting surrogate harmed party, whether it's the direct person or a surrogate, if there is a direct harmed party in the case, to name what is it that they need. We prioritize that. And then in that pre-conferencing, which we do as well, which Rami and I have talked a lot about, is kind of considered best practice, right, in participating in a restorative justice process, is you really need to prep people. And so we talk about and ask and invite folks in that conversation, what do you want to do? What do you feel like you need to do to repair this harm? We pre-conference with everybody who's going to be a part of that conversation, including community members, support people, etc., police officers. We invite officers to participate. So all of those folks in that meeting then in the conference are talking about what needs to be included with those guidelines and that structure. So, again, when we ask folks for feedback around the accountability contract that we created, most people are saying, yeah, we feel like we made a contract that repaired harm to the greatest extent possible. And if not, then we invite in the conversation, what did this not respond to, right? When we're in the conversation building that accountability contract, we're saying, did this in fact respond to every level of harm? And if not, then we need to go back and do some more brainstorming. So it's a pretty fluid process, but we have that structure to help guide us.
So, Rami, I think there's a couple questions for you now in the Q&A. One is about the program being resourced. So sort of thinking about, is it a single stream, diverse stream? Like, how does all of that work? I'm sure that's always of interest to folks when they're thinking about scaling up and building. And you talked about there was a period of time of building what this program is. And then a second question about the slides. I'll say point of practice for us here at the ABA. We have not had presenters share their slides because they are proprietary to them in our prior webinars, but I certainly don't want to step on either of my wonderful presenters' toes here if they would like to share those.
So just to go to the question of how is the program resourced, is that in terms of funding resourced, or is it in terms of different kinds of resources? Okay. So in terms of funding, we typically at the Georgia Justice Project tend to receive or go for funding that are not state-based or government-based funding, just so we can operate independently without the several grant requirements of some of the federal or state guidelines. It is still in the beginning process of receiving larger funding, so we're still applying for more grants because this is still new, so we need to show more data to be able to receive that funding. In terms of resources, as in volunteers, as in receiving cases, I would say luckily there is a huge community in Atlanta that's very interested in criminal justice reform and in restorative justice. So I've received a lot of folks who've been interested in wanting to volunteer and wanting to act as community members to advocate for the program or project. So I've done certain talks with different groups to be able to get my program's name out there. And also, just again, with the DA's office, they've been great with supporting me in giving me opportunities to train their staff, victims advocates, the prosecutors, and especially as well with the public defender's office, where I've been able to train their office around that. So those resources have been very, very helpful.
And there's a question directly to you, Ames, about, are you doing the meetings one-on-one or these with the person involved individually? And then I would say that there's a question to both of you, which is that I'd love to hear both of you answer is two parts. What's being done to keep a defendant from repeating? So thinking about non-repetition, recidivism, right? Reentry back into system engagement. And then is the cause being addressed? So maybe sort of either from a root cause standpoint or whatever the harm was in that way. And if both of you could take those secondary questions, that'd be wonderful.
Sure, I can just jump in for the first one there. So as far as the pre-conferencing, similar to Rami's program, we do individually meet with responsible party, harms party, community members, we meaning the facilitators. So who's ever facilitating the case, which is often myself along with a volunteer. Sometimes it is two volunteers that are facilitating. We offer those trainings and things in-house to get people up to speed, build capacity so that we can take more cases. So facilitators are meeting with folks individually beforehand to do that prep meeting conversation. And then in the pre-conference itself, in the restorative justice conference itself, it's everyone participating, meaning responsible party, harmed party, police officer, community member, any other support people that are involved. Sometimes we have cases, right, that involve several responsible parties. And so we've had cases where we've had 5 responsible parties in one circle. We've also had circles. I'm using circles and conferences, that word interchangeably, but we've had processes that involve folks that, each person has gotten a ticket, so they're both considered responsible parties and harmed parties, and we're able to engage in a conversation in that conference altogether, which is why the preparation meetings, those pre-conference meetings, are so important to really help set people up for success, we like to say, in the Restorative Justice Conference. Rami, do you want to start with addressing the other piece, and I can jump in?
Sure. So with what is done to keep the defendant from repeating and is cause addressed. So yes, as Ames mentioned, when pre-conferencing with someone, speaking to them beforehand and preparing them, I do work on addressing, what was the need behind causing that harm? What led you to cause that harm, and giving folks larger context and understanding for themselves to be able to understand why they caused something. And then afterwards, after our conference is done and they speak about those harms that they caused and what led to it, and an agreement is formed, I pair the defendant with a social worker who is, 1, able to assist them in completing the agreement, and 2, able to support them when it comes to housing, to employment, to mental health services if they need any referrals, just to make sure that, yes, we have one piece that is the restorative justice dialogue, but the other piece is making sure that they don't go back to the same environment or the same causes that led to why they were referred to us.
That you all offer that resource and connection point. We don't have the capacity to do that, but as part of our kind of orientation into the restorative justice program for us, we have folks go through a pretty informal assessment, but just so we get a sense of what else is going on in their life, in their family's life, that might be impacting some of their behaviors or contributing to why they offended, right? And so we've had cases where we've had to just put the case on hold for about 6 months because the family didn't have a home. And how can we expect a young person, if this person was the responsible party was a young person, but how do we expect folks to really tune into full accountability and being able to follow through and all the things if they don't even know where they're living, right? And so it's not, let's not hold them accountable. It's, we need to pause and support the basic human needs that exist right now, so that then we can, when we are able to re-engage in the restorative justice conversation and process, we know that some of their basic needs are being met, right? And so again, it's doing that assessment, helping connect them with other community resources to help with housing or food or counseling or whatever it might be, before and throughout the process. Even if that's not a part of their accountability contract, we really want to help set them up for success around that as much as we possibly can. We also, I'll just say, that's in part why we then bring in other people that they have relationships with into the conference, right? Because they're going to see us and maybe work with us for a couple months, but how do we help support and the development and foster the relationships that they have in their life currently? So maybe it's with someone at school, or it's a coach, or it's an older sibling that they really look up to, or it's a friend, right? If it's an adult case that we're seeing. So that's another kind of strategic move of inviting more people into the circle so that we can help support and build some of those relationships, or at least create the opportunity to do that.
And so we have a question directed, 2 questions directed to Rami, thinking, one about confidentiality and immigration, and then the other about social workers. I will make sort of a meta comment about confidentiality. Here in the United States, at the state or federal level, there is not a full confidentiality provision or legislation. So each individual state and each individual program is then managing confidentiality either in the presence or absence of state legislation. There There are only 13 states that have even touched on formally in law addressing confidentiality or admissibility requirements. So as Rami mentioned, right, a lot of this is done through memorandums of understanding and other formulations that are agreements on the ground. And so memorandums of understanding are simply not going to be the same as if you have a state level provision or another way in which confidentiality and admissibility is articulated. They are not binding contracts that carry the same weight that we would think of as other protections under law. And so, that may not answer the question directly, and I certainly please invite Rami to answer that, but I think we need to be clear about the fact that there is not anything at either the state or the federal level that is creating a set of protections and confidentiality and admissibility bars relative to restorative practices, whether we're using the term restorative justice, restorative practice, or specific forms of practice. So, victim offender mediation, victim offender dialogue, circle, family group conferencing. So it's a really very significant and ripe issue on the ground, both for practitioners and for individuals who are part of the process, for the defense bar as well, in thinking through with the rise and prevalence of restorative justice, how are we ensuring that the same constitutional protections, the same concerns that have come up over many, many decades within the criminal legal system, and an attentiveness to that. So Rami, I don't know if you want to take the question relative specific to immigration, but I did want to share that sort of writ large for our audience and have a sense of clarity that this is a patchwork approach at best.
Yes. So I will say when it comes to immigration, it's not that the USCIS or ICE will ask me for records. It is because we have a memorandum of understanding with the district attorney's office that is now a state document. And so in a case where USCIS or immigration services are able to obtain that and translate it themselves into, well, this is an admission, that may have adverse impacts on someone's immigration. So sometimes, and this is, I'm not an immigration expert, but this is what I've been told by lawyers of seeing a resolution through restorative justice may be interpreted to immigration services as an admission, which may cause immigration consequences. That's not always the case, but that could happen. So that's why I always advise folks of, if it were up to me or even the district attorney, this wouldn't be an issue, but we don't control what USCIS does. And there's a
social workers,
question.
I think.
Yes, so social workers are internal to the Georgia Justice Project. They already work within the organization. And so we don't hand folks up to a different agency, because then that also goes to confidentiality and what we do share. So they are internal with the Georgia Justice Project.
Might pivot to just so we can have Rami take a breath, right? And not be responding to questions back and forth. And I don't know if this is directed to you, Ames, but you did mention young people. So I don't know, thinking about Lyle's question about incidents involving youth occurring at schools or to and from school, and if there's an MOU that's allowing that.
Thank you. So about 75% or so of the youth cases that our program receives happen at school. And so we don't have a specific MOU necessarily, but we've been working with our school district since the beginning of this. Our Inglewood School District, we have several in our city, but the Inglewood School District specifically has been working to integrate and offer trainings around restorative practices for 4 or 5 years. So they're actually a little bit ahead of us as far as actual programming in the school district. Each school utilizes the practices differently. We've been working with them and they with us around how do we not, the goal is not to say, oh, the court has an RJ program, let's just send it to them. The goal, right, is to help support the efforts happening in the schools before one even gets a ticket and comes to the court and potentially the RJ program. So that being said, I get to work with, and our volunteers work with, all of the schools in our district, which is actually quite small. So Inglewood's actually only 35,000 people. We only have 12 schools, so it's quite small. But we work with staff and administration to invite them to participate in our conferences when it does involve an issue at school, because we want to know that school perspective and the impacts on the larger school community. We also, again, in those cases specifically, invite the school resource officer to join us in those conversations.
And then I think Amanda's question might be able to be both of you thinking about, which is when you can't reach someone, right? The question is, whether it's an address, a phone number, right? The ways in which people move and shift. What happens if you can't reach the victim in either of your programs? Where might surrogates come into play if that's the case, or even surrogates more generally, if you'd like to speak to that. And then we'll take the question from Gilbert, because I know it's very specific to House Bill 382, Rami.
So in terms of not being able to reach victims, that does happen sometimes where we're not able to get a hold of them. I personally will keep trying myself, and even the DA's office will keep trying to get a hold of the victims. However, if that is not an option, and if that just doesn't happen, then at some point we will have to decide if we're going to go with victim surrogate. So someone who has been through a similar crime, who can speak to the impacts of that crime and how it affects everyone. So we just we try to have victim surrogates there. Sometimes when victims don't want to participate, we have them, if they would like to record themselves speaking about the impact, or if they would like someone to read their statement, that's also an option.
That as well. And yes, I've been able to, we've been able to work with the court to give us more time to address those basic human needs before, and then give us more time to go through the RJ program if the family and responsible party is still open to that and want to do that. So we're able to kind of push out the municipal court process if we need to, up to a year. I don't advertise that, right? But we can if we need to, in order to be able to work with people.
So Rami, I don't know if you're working on HB 382 or have insights, but to the extent that Gilbert's asked that question, please feel free.
Yes, so I actually worked on that bill, and the Georgia Justice Project paired with a lawmaker who presented that bill in the House of Representatives in Georgia. What happened was it didn't make it through this first legislative session. People were interested. It was bipartisan, so both sides of the political spectrum signed off on it. I know that when we tried to join with another bill and trying to make that happen, the lawmaker was not very open to it because of the terms of restorative justice. And so we're working on figuring that out and trying to see if we reintroduce the bill or how we work around that. And for those who are not familiar, HB 382 will allow folks who come through restorative justice programs to have the same privilege as attorney-client privilege, or privilege in mediation. So it's not confidentiality, but it is a level of privilege where whatever is said to us is privileged.
And then the last question is really thinking of, and I know we've all grappled with this. I write about this. Many people are considering this, is the question of co-optation, right? You're embedding a set of practices, a theoretical framework, a philosophy that does not necessarily stand in alignment with a traditional punitive, retributive, adversarial criminal legal system. And so how to really scaffold against or protect against co-optation, whether it's as another arm of policing, the carceral system, and I think especially in this sort of acute conversation around deportation or incarceration, but maybe reflecting on how in your individual programs you're thinking about this, or even how that's being addressed and alleviated if possible.
Yeah, it's such a great question, and I'm thinking about it a lot. And as a community, as a program, we're thinking about it a lot. So I guess a couple things that come to mind is we're doing our best to help educate people around what restorative justice, what restorative practices are about. We've built our program from a restorative mentality. So in building our program, we are using some of the principles and values of restorative practices to build relationships, to share power, to engage in conversation around what is this? What do we want it to be? It's not a top-down model of, this person, I'm a program manager, now we're going to do this. It's really a different way of engaging in relationships and even the building of our program. And so through that, hoping to help engage in conversation around, do we in fact want it to remain in our municipal court within the carceral system? And the community in our recommendations, even from 3 years ago, was pretty clear that we want to see the program in a community-based organization. And so we're actually in the process of doing more kind of deep diving around how do we want to expand our program outside of the criminal legal system. And yet, we're still going to be taking cases, right, from the municipal court, from our neighboring municipal courts and PDs and things like that. And so I think, it's not an easy answer, but I think part of at least what I try to hold in my mind and in my heart and in my practice is we have to be real about the potential for that co-optation in order to be authentic about how are we going to be intentional around building capacity within our communities so that maybe even further up the stream, some of these cases, at least in our case, don't even get to the municipal court, right? They're actually held and dealt with and supported within our community neighborhoods and systems and community pods, all the things, right? And so it's kind of a both and. It's just like an acknowledgement that is very possible and it can exist. It's by doing the work in a way that's restorative that hopefully helps to change relationships and engagements in how we're even doing the work to show people, oh, there's a different way to do this that works and is successful. We have data to show that. And putting efforts towards, at least this is what our program is doing, putting efforts towards how do we be on more of the front end of things and support the capacity in our community so that some of these cases are not even brought to the criminal legal system. So much more to say, so I really appreciate that question, but I'll pause there and I look forward to hearing your response, Rami.
Yeah, that's definitely a great question that I think about also a lot. I think for me, just there is a level of separation with the district attorney's office because I work for a nonprofit. So it's not within this, it's not a state program. We don't receive that state funding from them. So there's no financial pressure on this is what you need to do with this case or that case. Realistically, yes, we are getting the cases from the district attorney. So I have to work with what I am referred, but we've tried to set as many layers of separation with them as possible, starting with the confidentiality aspect, starting with if you're deciding on anything legal with a defendant, you figure that out and make sure they're also represented. And also getting the forms signed, defendant advisement form, victim advisement forms. So we just have that clear separation between our office and theirs. That is what I'm able to work with at the moment. But I'm always trying to think of ways where we can move to more community-based approaches as well.
So I want to thank also for that question. I mean, part of what I'm hearing from both of you respond to is that we also have to be thinking upstream, right? So it's one thing when interventions are put in place after a ticket, after arrest, after a charge, but what is it to not just be pre-adjudication, but actually be really sort of pre-charge, pre-arrest, and at the earliest, most upstream stages to diminish even contact with the criminal legal system. And so when we start to position restorative justice and that continuum, right, where really we're investing at that upstream, then it also can be that restorative justice is functioning as the complementarity and the necessity of addressing especially the harm that someone who's experienced harm has gone through. You know, our current system is deeply dissatisfying to those that have experienced harm. It supplants their agency, right? There's lots of ways in conceptualizing that. There's a lot of research on that. And so to the extent that if an intervention is truly needed that is criminal legal, then is there still a restorative framework and still a restorative possibility, even if we're moving along that continuum of the criminal legal system? Now, that does not remediate all of the potential for both net widening and net deepening, right, as we think about disparities. But I do think we have to have the yes and, the both and, to use Ames's language in particular, which is we need to be looking upstream and investing still within the longer continuum, because at the end of the day, you know, we still have a criminal legal system, we still have that architecture, and reforms have to be looking across and within, because without that, you know, the urgency of the moment when a case is coming to Rami or a case is coming to Ames, is that individual and those individuals deserve the access to restorative processes and restorative practices. And until the larger system, right, is starting from that as an initial framework, not the adversarial punitive, we still need to respond to people in the moment, and having that real sense of clarity of what that looks like, but definitely coupled with going more and more upstream, both in reform and in services and in intervention in the ways in which we focus. So I think that was a really significant and important question, and doesn't necessarily cover all of the ways and aspects. So, but I want to deeply, deeply thank both Rami and Ames for joining us today. It's both been a pleasure to hear about your programs as discrete, but how they come into alignment, right? You know, how is it that in Inglewood, Colorado, you know, at the municipal court level, we're seeing restorative practices in operation? How is it at the felony level in Georgia, you know, that we're seeing this coming together, you know, in that way, you know, in Atlanta in particular, very different places in the country, very different types of cases, but still coming with the through line of restorative justice and restorative practices. And I think that speaks to the importance and salience of these continued conversations. So thank you again for taking time for joining us today. The recording is archived for those who want to come back to it. And I invite anyone who's interested in our final conversation of the year that will be occurring on October 26th, which will be conceptualizing what's the role of judges. So how are judges stakeholders in this question of restorative system design, in the use of restorative practices, as stakeholders within that larger continuum? And so please do be on the lookout for that. Take care, everyone.